We'll get back to more on that in a minute. The other big news today from our perspective is a win for religious liberty in the state of Missouri. So Trinity Lutheran battled this all the way to the Supreme Court with help from a legal defense group, and they won. And they said Missouri couldn't discriminate against them just because they were a religious school. Mike McShane joining us right now from the Show Me Institute to talk more about this Supreme Court ruling. Michael, how are you?
I'm doing well. How are you?
I'm doing well, thank you. I had a chance earlier to speak to somebody from the defense group who fought this to the Supreme Court, and they were simply thrilled with this ruling today. What is your read on it?
Yeah, I think they absolutely should be. I mean, what we saw was a broad majority of the Supreme Court, so not just like a narrow 5-4 like we often see in some of these, but 7 Supreme Court justices say that religious organizations have the right to participate in what otherwise would be neutral government programs. So if there's a grant program to resurface your playground and you happen to be a religious organization, you should not be penalized for doing so.
So what is it? And I asked the national attorney this, and I don't know if he was as versed on it as we would be from a state perspective, but I'm wondering what the scope of that ruling is. Do we know of other programs and opportunities that might exist now in the state of Missouri to schools that happen to be connected to a religious organization?
So that's the thing. It was generally a pretty narrow ruling. There is, and in a couple things you've seen these mentions of footnote number 3. So in Chief Justice Roberts' opinion, which was joined by everyone from Justice Kagan, Justice Alito, all joined in on this, said sort of specifically, we are issuing this opinion on cases where the identity of the organization caused them to be excluded. We are not weighing in on if the use of dollars is for something. So they pretty clearly decided to punt on things like school vouchers or other programs. But what it does do is, I think, give a real shot in the arm for if in the future someone talking about school vouchers or others of these use cases, they have the opportunity to do so. And actually, interestingly, both Justice Thomas and Justice Gorsuch, in concurring opinions, spoke very specifically about this and said this should not just apply to organizations that might be excluded based on their religious identity, but also if they just choose to use dollars for religious purposes. So I think that there is ample opportunity in the future for this to broaden, but it wasn't done by this case directly.
Well, darn. Yeah, I was kind of hoping I assumed that it would be a fairly narrow focus. It got down to a question about the Establishment Clause, which I brought up with the attorney, and I think you've got to go pretty far to argue that any public dollars given to a school that happens to have a religious affiliation automatically somehow violates the Establishment Clause. I know that I'm not an attorney, but the way I interpret that is it has to be the government endorsing a religion. But I would think as long as the opportunity is made available to religious institutions of all colors, of all religious backgrounds, I'm not quite sure how they would perceive that to be some sort of violation.
No, exactly. I mean, I think that the First Amendment to the Constitution gives us these wonderful guardrails, right? On one side, we have the Establishment Clause that says that the state won't try to establish religion. So, if for example, the funding would only go to Lutheran schools to rehab their playgrounds, then we would have a problem. We would say, whoa, you're really putting your thumb on the scale for Lutheran schools. And then on the other side, the other guardrail is the Free Exercise Clause, so that we have the ability to be religious people and for there to be religious organizations. So I think that's the court put themselves firmly in the middle of that ground and said, listen, a secular program that is done in a neutral manner, in the sense that the application process that Trinity Lutheran had to figure out or had to navigate didn't give extra points if you were religious, and it didn't punish, well, the ruling did, but in the future it wouldn't punish people based on being religious, and that's where government should be. We don't give them an unfair leg up, but we don't unfairly punish them. We stay neutral towards religious organizations.
Yeah, and I'm glad that you pointed that out. You know, I talked to the lady who was the director of that preschool back when this case was first argued before the court, and she pointed out to me that of the students that she had there at the school, only 3 of the 60 or 70 kids they had enrolled in this program were actually the children of parishioners. The rest of them were town folk who needed a daycare or preschool, and that's where they sent their kids.
Well, go into Cardinal Glennon Hospital and ask around the people that are being served there. Go to St. Louis University or any of these places. You know, folks take state Medicaid dollars to Cardinal Glennon. They take Bright Flight scholarships to SLU. You know, you have the opportunity to look around there and say, oh, wait, a bunch of these folks might not be Catholic, or they might not. They are just participating in this, and these folks want to serve them and help them. So, look, I think that one of the things that made America great, if you go back and read your Alexis de Tocqueville and others, is this great civil society where we don't always immediately appeal to the government, but try to work with one another through organizations. And some of those organizations are religious and others aren't. But we have this proud tradition of religious organizations feeding the hungry and sheltering the homeless and educating children and providing health care. And, you know, today the Supreme Court stood up for them and said, you are a part of our society, you do great things for us, and we should treat you fairly. Yeah, well, Mike McShane, McShane, I know you've been following this story, and I'm glad we got a good resolution to it today. Thank you for your time. Oh, thanks for having me. Take care.
Thank you. Michael McShane with the Show Me Institute. ShowMeInstitute.org is their website if you want to go there and read more on it. So it's not going to have as broad an impact as some of us had hoped that it would. I'm thrilled that they won because it seemed like a no-brainer. And it also struck me that the prior administration in the state of Missouri, the Nixon administration, had been dead set against any of this money being given there because a lot of the folks on the left have this slippery slope concern that that's the next step toward approving vouchers for private schools. And their union pressure won't allow them to even acknowledge that that might be a possibility. And all we can hope is that we head that direction at some point, because it's silly to argue that by giving state funding for education to a school that is parochial, that you're somehow endorsing that religion, as long as the money's available to all private schools. If a kid wants to go from their public school to the local Catholic school, their parents paid $7,000 in property taxes. You take that voucher for $7,000 and you go apply it to your tuition over here. It's that simple. I don't see how that violates the Establishment Clause or endorses one religion over another. There are easy ways around it, but that is a huge threat to the people in the public school system because they don't want or need the competition in their minds.